Okay, why does the state object? Or why do you think he waived his right to a jury trial?
Well, obviously this case is a little unique in that it started off as a criminal case.
Right.
But back on October 28th of 2024, we filed a motion to amend the charging information to include facts. The court granted that request. And then we also turned around and just once that count was included, we turned around on October 30th and we dismissed the criminal counts. And that request was granted the following day on November the 1st. So essentially, we were left with only one count pending, and it's a civil infraction count. All of this was discussed at a hearing on October 29th of last year, at which time a bench trial was set with no objection from the defendant that it was being set for a bench trial, and it was set for January 15th. At this time, on October 29th, the defendant was also appointed Lori James to be his attorney. We then had a hearing on December the 11th, at which time the bench trial date was confirmed. We then have a hearing on January 9th of 2025, in which the bench trial is vacated and a pretrial set for March 13th. 13th, Senior Judge Molter handles the hearing. This is a hearing in which Lori James asked to withdraw from the case. The defendant did not appear for the hearing, only Ms. James appeared. The court went ahead and set the matter for a bench trial on April 2nd, with, of course, no objection from the defendant or defense counsel that it was being set for a bench trial. And essentially the court agreed that Ms. James could withdraw from the case once she notified the defendant of his bench trial date. And so on March 18th, defense counsel filed a notice to the court that she had informed the defendant via email of the bench trial date, and then essentially the court allowed her to withdraw. Ultimately, we are only dealing with a civil infraction count, so the civil rules of procedure are applicable at this point. And Rule 38, Jury Trial of Right, Section B, a demand, it states that any party may demand a trial by jury, but essentially it must be filed 10 days after responsive pleading or to the complaint or a counterclaim, cross-claim, or other claim is due. If no responsive pleading is required, then it's within 10 days after the time such pleading otherwise would have been required. So my point is that time period has passed by several months. This demand for a jury trial should have been filed last year. It was not filed. The bench trial had been set and even continued, all without an objection from the defendant. So he acquiesced to the setting of a bench trial as opposed to a jury trial. He never made a demand for a jury trial until a matter of, I think, approximately a week before the bench trial date. So at this point in time, it's our position that he waived his right to request or demand a jury trial, and we would ask that it be redocketed as a bench trial.
So you're looking at Trial Rule 38B, and so you're saying that because in October he did not request a jury trial timely, right?
Correct.
Okay, well, what about the prior demands for jury trial that were filed on, this predates my getting into this case, so I gotta find them now. There were two prior requests for a jury trial in this matter.
So those would have been made when the criminal charges were pending and not the civil charges. So the criminal charges went away, and then we're only the civil infraction count. He was in court at the time the bench trial was set on that civil infraction count, and he never made a request for a jury trial at that time.
What was the date that the civil infraction was filed?
It was filed October 28th, and then we had
October 28th of 2024.
And then we had a hearing involving all of this on October 29th, 2024.
So that, okay, so, all right. Well, I think the 20, oh, okay. So the 29th of 10/29/2024, the infraction was filed. So, and you're saying that he did not, within the requisite time period, ask for a jury trial?
That's correct.
Okay. Well, let me explain to both of you what I did in filing and approving the jury trial. So, just for clarity of record, there was prior request for jury trial made in this matter, which was 9/9/2024, and also there was one prior to that. That doesn't matter. There was another one somewhere up there, but those predated the filing of the infraction, and that's something I did not realize. So that's my error as far as that goes. Mr. Manley, do you have any response?
Yes, sir. First, I would like to re-urge my motion to dismiss.
Okay, we're not talking about that, sir.
Okay,
Sir, we're not talking about that.
I am. I'm finna answer. It's just I'm leading with that, but I would like to re-urge my motion to dismiss. Equally, I would like to state that due to the criminal nature of this particular civil infraction, that how the prosecutors, at their own behest, were able to turn this back into a civil matter and turn it back into a criminal matter at their own will. That has put me at risk, put me in a double jeopardy standard, even after the matter had been dismissed, and even during the course of proving that Rozzi in fact fabricated the probable cause affidavit and lied about everything that even have me with a civil infraction. So it is my contention, that's why the fruit of the poisonous tree doctrine should apply, as well as the double jeopardy issue, because I never would have even had this a criminal matter had not Rozzi lied on me. So seeing that he lied on me, I'm standing before you now. And a simple way to even look at it, this is a criminal court right now I'm in. So if it was a civil infraction or civil, I should have been in civil court. But I'm in criminal court.
Let me explain something to you, sir. This is not just a criminal court. This is a court of general jurisdiction.
Oh, I had no idea, sir.
So I don't agree with you on that.
I had no idea. I had no idea. I'm a Texas resident. Found myself in Indiana court being lied on.
Well, okay. Well, as I tried to tell you, we're not dealing with your motions at this point. I'm dealing with just the issue on the jury trial and their objection to that.
The reason why I state I'm saying claim or feel that a jury trial is needed in this matter due to the criminal element of this, that this civil infraction was converted into or turned into. It was no longer a civil infraction once the criminal element augmented it from civil to criminal.
Well, it started. Okay. All right. So, Ms. Pitstick, do you have anything on that? Any comments you'd like to make?
No, Your Honor.
Okay. All right. So, okay. All right. So, just as the procedural posture of this issue, so on March on March 27th, 2025, the court had approved the request for a jury trial that was made by Mr. Manley on 3/14/2025. This infraction count was only added on 11/4/2024. So under the trial rule 38B, within 10 days, a request should have been made. So the state's objection to the jury trial, the court under trial rule 59 would correct the error made by the court and would grant the state's request that a bench trial be set. As no pleading was done with requesting a jury trial in a timely manner under 38B. So, okay. So now let's move on to the Mr. Manley. These are all your motions that we're dealing with. You had filed on 321, motion to suppress evidence, or in the alternative, motion to dismiss. You've also filed a motion for jury trial on 3/21/2025, and that's already been addressed. Or in the alternative, dismissal of charges, and which is repetitive, and then motion to suppress, and or in the alternative, motion to dismiss. So a bunch of repetitive motions here that can be summarized as motion to dismiss or suppress evidence. Is that correct?
Yes, sir. But for
Okay.
different procedural reasons.
Well, it's either a motion to dismiss or suppress. I mean, there might be different grounds for each, but they're all very repetitive as far as you're asking for the same relief from the court. So let's address these motions now. So if you could explain what evidence are you ready to present any evidence as to why the charge should be dismissed or suppressed?
Yes, sir. I've submitted evidence with the motions that should be attached as the attachments. There is proof that there was no way the statements that were made in this probable cause affidavit. See, this is what I'm confused about. Is this is criminal in nature. That's why I'm requesting a bench trial.
We're dealing with the infraction count at this point, sir.
Okay. Well, the infraction
matters have been resolved. Those have been dismissed.
Okay.
The reckless homicide, the criminal recklessness, those are gone. What we're dealing with is only the civil infraction. That's an issue right now.
Okay. Well, with concerning civil infraction, there was no way that I ran a stop sign or failed to yield, as the ticket states. I was hit in the rear by a person high on methamphetamines, driving high, and which put other pedestrians and drivers and property in danger. So that was not something that I done, and it's I'm not guilty of even yield. I did everything right. I did not fail to yield, as Rozzy lied and said in his ticket, because he had pretextual reasons and pretextual lies that he stated to the court and sworn under the penalty of perjury and perjured himself before the court. and this is a disgusting matter that I'm still here discussing this with this evidence that this man has lied on me, and I'm still dealing with even a civil infraction, let alone I'm grateful to God for and the wisdom of Judge Woolley for seeing through all the shenanigans. But here I am still dealing with a civil infraction over a cop that you guys know flat out lied. It doesn't make any good sense to me.
Okay. Well, sir, the issues that I just heard you talk about are more appropriate for a trial. But what I'm interested in here is your motions for dismissal or suppression of evidence.
Right. They should be dismissed based upon the fruit of the poisonous tree doctrine, as well as double jeopardy standards, as I'm stating in the motions, the four corners of the document. I feel that when the court dismissed the matter on December 18th, 2023, upon the prosecutor's motion and that was signed, now it's a double jeopardy matter. That same ticket, I'm standing before you today, if it was a civil infraction at that time, or I don't know if it was civil or criminal at that time, but you guys say you're a court of general jurisdiction. It was either or, if I'm understanding correctly. So now I'm in an either or position. Either way, it should be dismissed for double jeopardy, because even though this is an infraction, it has criminal penalties that could be attached to it, and the severity of the penalty, given what the constitutional standard is in the state of Indiana, as well as the United States Supreme Court. So it should be a double jeopardy. It is a double jeopardy matter, and it should be dismissed upon those grounds, and or suppressed, because due to the fruit, it was fruit of the poisonous tree. Because you can't have a liar lying on citizens and persons traveling across the country, and a cop will take it upon himself and jeopardize himself to lie with such clear evidence that what he's saying is a lie. You got video evidence that he lied. You have pictures proving that he lied, and his own statements that he wrote on a ticket, unless this is governmental records, and he lied on governmental records, which is the ticket, the Indiana Standard Police record that he wrote. When you have another cop who was the Indiana State Police trooper, wrote a totally, both of them wrote the same narrative initially, then those two narratives somehow diverged, and I found myself in a world of trouble, being incarcerated, falsely accused, extradited from my state. I mean, this is, I don't know what to say about standing here today. Well, I'm glad. I'd rather be standing here than standing there, as I was in chains. They had me in chains last time I saw you. Chained from my hands to my feet. Had my waist chained with a chain because a man lied on me.
Well, so as far as you're asserting that there's, I mean, you've said a lot here as far as that it's double jeopardy, and basically, in reading your pleadings, and you're asking for the court to dismiss this, and I heard your arguments. Do you have any evidence you'd like to present?
I attach with those motions evidence supporting that. For instance, if you look, there should be attachments such as pictures of the post-accident pictures showing the front end of the vehicle that I was operating, and it clearly did not crash into anyone from the front. So who's the accuser? Rozzi, where is he now? I would like to face him since he's here, and also for warrant of prosecution since he's running. The cop, he can't even come to court and say what he said. I just need him to come to court and say what you said.
Well, sir, that's what we have trials for, sir.
I'm looking for him.
And, we're not.
I
here
want to
for the
meet him.
trial
I want to
today.
face him. I'm hoping
Well,
can I face my accuser? I'm looking to face my accuser.
Mr. Manley, what we're here for today is for you. On your motions. That's exactly what you're entitled to is to face your accuser, and that's what the trial is set for.
Okay.
But what I'm asking you about is you're wanting it to end before it gets to trial.
Okay.
You have to show me that there's a reason for me to grant the relief you're asking
The
for.
reason
And
I stated
I'm only hearing from you very conclusory allegations, and that is not evidence.
the pictures are not attached with my motion.
You've provided stuff that's already part of the record with your pleadings, but that's not evidence. It's the probable cause affidavit. It's the things that are already part of the record. That's why we have trials.
So-
It's for these.
So the pictures proof that's before the court. That's not evidence.
Well, it's not evidence that it should be suppressed. That's something for the trier of fact to do at the trial.
Yeah, and I elected a jury trial because this is a criminal matter being hiding or positioning itself as a civil matter.
Well, it's a civil infraction, so that falls under different rules. So, and that's why my prior ruling was made.
So the initial ruling that came out in December that this ticket was this matter a civil infraction in December?
As of December, it was.
I'm saying when December 18th, 2023, when the court dismissed the ticket, or when it was dismissed, was it civil then or criminal?
In 2023,
Yes, sir.
this started out as a level 5 felony.
No. Okay.
And there's no dispute in the record about that.
Hold on. What I'm referencing, Judge Bailey, is the
Yeah.
when the ticket was written on 11/12/2023. Taking a step back, 11/12/2023, the day of these accusations and allegations stem from. Was that ticket on that day a civil infraction at the time it was written?
No, it was not. The civil infraction, that's what Ms. Pitstick pointed out to me, and that's where I made my mistake that I corrected in this hearing.
Well, that's the same thing I'm looking at. If it was on the 11/12 on 11/12/23 when the ticket is from its intention and from its exception, it was a criminal matter. So now it's all of a sudden a civil matter. How, that's why I am standing and still requesting.
On 10/29/2024, sir, they filed the infraction count, and that is not a criminal action.
If I may speak, Your Honor.
Yeah, of course, Ms. Pitstick.
I think some of the confusion lies that initially in November 2023, our office had filed a civil infraction ticket.
Okay.
And then more about what happened and dismissed that ticket and filed criminal charges. What Mr. Manley doesn't understand is that we can file charges and dismiss them without prejudice and refile them almost as many times as we want. And so that initial ticket was dismissed without prejudice. The criminal charges that were subsequently filed were dismissed without prejudice. So there's no double jeopardy claim. You've not presented any sort of cogent argument whatsoever to support a motion to suppress or dismiss. This is a civil issue at this point, so a suppression motion is not even appropriate. He's had sufficient opportunity to respond to your questions, Your Honor. At this point, I would ask the court to go ahead and deny his request and set this matter for a bench trial.
Okay. Mr. Manley?
I fully disagree, and
Okay.
I'm standing on my initial filings, and if I have to appeal, I will appeal because
Okay.
I feel that this is right now is very disgusting that I'm sitting here discussing this, and it was from the inception of the filing. It was I on 11/12/2023 was this a criminal matter from its inception, and where did it change? And but if it changed and the stakes were raised, that put me in double jeopardy, according to the state of Indiana's laws as well as the Constitution of the United States, because of the penalties and the severity of the punishments that were attached to these tickets. That's enough for jeopardy.
Well,
That's enough to put a
sir,
person at risk.
sir, I appreciate your arguments. The thing that I keep hearing from you is, you know, what we are literally dealing with an infraction count at this point. I'm hearing a lot of arguments about the criminal issues that predated this filing of the infraction, and those just simply are not an issue. The penalty for a level 5 felony is, I mean, that's a criminal penalty. There's no question. That's already gone. What we're left with here is an infraction count. And that's literally what we're talking about. So I've heard no argument that you've made that would lead me to believe that there's double jeopardy here, despite your contentions. And
Well, just as the attorney just said, she can file.
hold on.
Okay.
Sir, I give you a chance to talk, but now
Okay.
it's my turn. All right. So, you know, the basis of what I've heard from you on your motion to suppress or dismiss is basically the things that have to be tested in a trial, where you confront your accusers, and as you have a right to do that, and you know, and bring all this up at the trial. I'm not here. I've not seen or heard any evidence here that tells me that this is rooted in fraud or misconduct. That would be for the trial to, you know,
Wow.
I mean, the state has to prove the case against you, and so I'm going to go ahead and deny your motion to dismiss, or in the alternative, to suppress the evidence. That would be the ones that were made on 313 and 321, and then so you have a right to have a trial. And what we'll do is reset this for a bench trial.
Okay. I also want to
Address all
request.
these arguments, okay?
I'd like to request also a motion for the court to appoint an expert witness.
There's no, what, an expert witness for what?
An expert witness to gauge the speed of travel that that vehicle was traveling at. We already know that the operator of that vehicle was indeed high on methamphetamines and drugs. So I want to get the court to put forth a motion for the court to appoint an expert witness, and or so also a motion that the court compel the state's evidence at this time of any more evidence that they may have attained or throughout this process.
Ms. Pitstick, have you made disclosure of the evidence to Mr. Manley?
Yes, during the
Okay.
course of counts that were pending, he received the evidence in the matter.
Okay. Is there anything you're missing, Mr. Manley?
Well, I would assume so for the continued effort by the attorney Pitstick to pursue this, knowing good and well that this man has lied, and it's just something don't feel right about it. Something ain't right, and I want to know what it is. I can't wait to find out.
Well, so let's address your first motion for an expert witness. So you're wanting an expert witness to show the speed and the direction and all this other stuff of
Yes, sir.
the car that
Yes,
hit
sir.
you.
That's
Well,
very important.
I don't understand how that has to do with a failure to yield at a stop sign.
Well,
so
this is
I'm
what
gonna deny that.
this is what's been said about. This is what they're saying. So, if someone has created a very unsafe driving, unsafe road condition for you, traveling at a high rate of speed, how would you be able to say that I yield and you didn't see this? The cop didn't see this, nor can he say that which I have him on video saying these things. He's on video saying that he didn't see me. He can't prove that. So
Again, Mr.
I don't even know what this is about.
I
So if
pointed
you didn't
back
see-
to my prior statements is the issues that you're bringing up.
Yes, sir.
Those are
Okay.
appropriate for trial. Okay.
Okay.
So, but as far as an expert witness, as far as what you're asking the expert witness to do is something that I don't see whether it points to the fact of whether you did or did not fail to yield at a stop sign. So I'm going to deny that. You've also asked for, I forgot what the second thing you asked for was.
Motion to compel for any
Yeah. So
evidence relating to failure to yield at a stop sign.
yeah,
Any evidence that the state has in its possession relevant to the allegation failure to yield at a stop sign.
You're entitled to that information, and as she's explained, that's already been given to you. And I asked you, are you missing anything?
Yeah. Okay.
And you
So,
said,
so what I'm missing is the witnesses that I'm the witnesses who the state is relying on. So I want a motion to compel the state's witnesses who the state is relying on to say that I failed to yield.
Well, that's a reasonable request that I'll grant. Is the state will have to divulge who their witnesses will be. That's fine. Yeah, I'll grant that. So, all right, Ms. Pitstick, do you have anything else before we set a bench trial date? Ms. Pitstick, can you hear me?
Yes, I can.
Okay. Do you have anything else before we move on?
No, I do not.
Okay. So, all right. So let's get a bench trial date set, and prior to the bench trial, if I'll just grant the request that the state would provide a witness list to Mr. Manley prior to trial. So I don't know if the court can hear me. As far as, let's get a date set. I would assume this would be maybe a couple hours.
Perhaps, Your Honor.
Yeah.
Court staff is telling me that June 4th is available.
June 4th. Let me make sure. June 4th. June 4th on a Wednesday. In the afternoon or morning?
I believe the entire day is open at this point.
Okay. I have the afternoon available, so I could be there by 2 o'clock. Well, hold on. You're on a different time, right?
Correct, Your Eastern.
You're on Eastern time. Okay. So let's see. 2 o'clock.
I would like to say around September for me.
September?
Yes,
Why September?
because I will not be here.
You will not be here.
No, I won't. No, sir.
Why?
I've been in jail a long time. I plan on traveling. to get my
Well,
mind
sir,
off all the stress of this,
this has to be taken care of.
off this.
I'm not going to continue this out to September.
Okay.
That's fully 5 months from now. It's bad enough that we're in June,
Right.
but my calendar just simply won't permit it any quicker than
Right.
June. So I'm okay with June.
Right. I've tried to get it resolved sooner than long ago, but due to the ineffective counsel supplanting my defense and not really being a defense attorney but being a pawn for the state, I've been unable to really get get this matter resolved in a reasonable time.
Mr. Manley, I understand that, but those are what we're dealing with now is you've chosen to represent yourself, and as far as arguments about your prior counsel and all that, I don't know anything that happened between you and your lawyer, and it's irrelevant at this point because you've chosen to represent yourself. Okay, so but I'm not going to continue this out to September to get this done. Now, having said that, this is in person, but if you choose not to be here, the trial can happen without you being present. Do you understand that?
Well, then it'll be criminal again.
No, it's not. If you have notice of when the date is, and you choose not to be here, because you don't even have to do anything. You have no burden to prove anything. Because the state has the burden of proving by preponderance of evidence that you did run the stop sign. That's all they got to show. And anything that they present, you are entitled to cross-examine the witnesses that the state brings up, and that's where you get into the arguments you've made today. But if you choose not to be there, then the court would assume that you're waiving those rights. Do you understand that?
I plan on being there, but I just want to plan it around my availability, and June will not be I wouldn't be available in June. I've submitted or filed motion for speedy trial, motion for jury trial on several times. I've been incarcerated, falsely accused, thrown in jail. You would want to take a break too if you was me. You would want to take a break too if you was me. You would want to take a break too if you was me. If you was falsely accused and thrown in jail.
Well, but you got to understand that this is to ask to set this out to September. That's just too far.
Well, I tell you what, try having some handcuffs on you. And somebody handcuff your feet. Put some handcuffs on your feet and your waist.
Listen, Mr. Manley, I'm not going to sit here and debate and argue with you. I'm not setting it out till December. So what date in June are you available?
Like I'm saying, I won't be available in June. If you, that's what I'm trying to get to put it at a date where I can be available.
Give me a reasonable time prior to September when you are available.
August.
That's still, what about July?
The end of July.
I'm willing to work with you to a point, sir, but you're pushing my buttons here.
I sure hope. I'm not trying to push any buttons. I mean,
Well,
I'm just a person who's knowing that I know what the situation I'm in. I know where I come from. I know I've been lied on. I know I've been falsely accused, and I don't understand. I've been laid it out the record real clear before everybody, and I just don't understand while I'm still going through this process, and while the state is being aggressive or what you call overzealous and pursuing a ticket that now they saying is a civil infraction. But everyone who's being able to pull my record, they see a level 5 felony. Everybody that's looking at my record as I go apply for jobs trying to rebuild my life, they see a felony on me. They don't see no level on paper. People, employers, they see a level 5 felony. They don't see a ticket. They see I was accused of a level 5 felony. So it's so I don't. So this is very new and novel to me that I'm dealing with now a civil infraction. But I was in jail. I never been in jail behind no civil infraction.
Listen, Mr. Manley, I can't keep going in circles like this. All we're trying to do is set a bench trial date. And I keep hearing the same arguments over. I've already addressed this, okay? I don't have all day to deal with this, okay?
And sir, respectfully, I don't have all my life to deal with that. I don't have my life to deal with that. They playing with my life. They playing with my life. I've been in jail, put in jail, falsely accused.
I understand, and that's what the trial is set for, so that you can bring all that up at trial, okay? So what we need to do is set a trial date, okay? In July, is there a date for the court in July?
July 23rd. July 23rd, Your Honor.
July 23rd. That is a great week for, and I can do it at any day, any time on the 23rd.
I think the officer is unavailable that week, Your Honor.
Okay.
The liar is unavailable.
Well, Mr. Manley.
Yeah, he's a liar. He's a liar.
Mr. Manley, I'm going to tell you right now, stop. There's a certain amount of decorum, and that's not...
No, it's the truth, though. I can't call a liar a liar.
It's your allegation, okay? I'm not going to stand for that.
Okay. Under the penalty of perjury.
I can't get into your mind and tell you what to believe, but you in court, you don't start calling names to anybody.
No, sir. No, sir. This is not me name calling.
Well,
It's not me name calling.
Mr. Manley, that's enough. Stop. July 23rd at, how about 1 o'clock? Does that work? Does that work for the court?
On July 23rd, the officer is not available.
Okay.
But
what's the next
court
date?
Court staff indicates that July 24th is available, and the officer is also available.
Okay, July 24th is fine. Mr. Manley, does that work?
Yes.
July 24th?
It's whatever you said.
Okay, July 24th at what time? What would work?
The whole day is available.
Okay, how about July 24th at 1 o'clock?
Which time zone, Your Honor?
That'd be your time. Eastern time.
So 1 p.m. Eastern time.
Yes. All right. Okay. Mr. Manley, does that work for you?
Yes. How can I get a copy of this Zoom session? This conference here. I'd like a copy of that.
That's fine.
Yeah, I'd like a copy of this. Make sure that the court reporter, I'd like to put forth a request that the court reporter or whoever's taking record of this, keep a record of this for records.
You're going to get a copy of the court order of this hearing. Is that what you're asking?
No, I'm talking about the copy of this Zoom meeting, this conversation, and this back and forth that we're having dealing with this matter.
All right, that's fine. Yeah, the court reporter, if you would just burn a copy to him, send it to him. All right? So, is there anything else we need to address today?
No, Your Honor.
And Mr. Manley, anything else? No?
Yes, I think it's very
that we haven't already covered.
obviously that no one has done. Well, I'll leave that alone. I'll leave it alone at this point. But I would hope that Rozzy get fired and lose his job, because I don't know what other persons that he has done this to, and it's my goal to help somebody else that this has happened to. Whoever else this has happened to, I would like to help that person also find and get to the root of this liar, because you can't have a poisonous tree bearing this kind of fruit, and persons who are on the end of the receiving end, and this guy's still reaping the benefits, and I'm reaping the detriment, court dates, and he's still getting a check for his lies and harm that he's planted in the community. Ain't no telling whoever else he did this to.
Okay, Mr. Manley. Well, thank you. So, so you remember what I told you about if you're not here, that the trial can go forward. Okay, you understand that?
Well, I'm in a fighting stance. I'm not running.
And I'm not telling you not to do that.
Right.
What I'm telling you is that if you're not here, that we can go forward with this and get this.
So so that I be clear.
Being,
So that I be clear, you can go forward with a civil matter.
yeah.
This is a civil matter. So at what point does this civil matter turn to a criminal matter?
It doesn't turn to a criminal matter, sir. I don't know where you're getting this. It's a
Well,
civil
what I'm
matter.
getting it from is that
It doesn't turn to a
what
criminal
I'm
matter.
understanding is that I heard earlier that there was a mechanism called dismissal without prejudice, and that dismissal
Yes.
without prejudice, if you can just back and forth, because this was already dismissed. See, if this was a civil matter, it was already previously dismissed. So if it's civil, it was already previously dismissed. It was already handled. The lawyers got paid.
Listen,
The liar,
what I tell you,
the liar,
what I tell you
Rodney
about-
Clemens, he got paid.
Mr. Manley,
All the liars and the drunks and the drug addicts and got paid
Manley,
for lying on me.
I have told you, I'm not going to tolerate the inflammatory rhetoric, okay?
Why the truth is inflammatory? I'm telling the truth. The lie should be inflammatory.
It's your truth. It's your truth. This is a court. There's two truths, yours and the other.
But there's only one truth, and that is God. And I know good and well that you can't have two truths.
And you know what?
If I,
And
you can't have two truths. You got to have one.
I'm not going to dispute that. So, but I think we're done here. So on the day of trial, you will be able to bring up any evidence you wish, and then we'll have a full entire trial on that date. And so, do you have any questions for me?
No, I've
Okay.
already.
I will
I've
see
said
you
I'm trying
then
to.
on
I've been trying to
July
not say much
24th.
because this is a very painful situation for me. This is a very. This is a very. What I would say. Just like and I didn't know. I didn't know until my nephew had told me that KKK was the home of the Indiana was the home of the KKK. So these kind of truths, and when you find this kind of stuff out, it really just makes me angry. And I know what happened to me, and I'm still dealing with a civil infraction in a court that can see clearly. Everybody can take their glasses off and look at the truck and see that it would nobody. I didn't crash, but because this guy wanted to lie, he made up anything. He said anything just to have a black man accused of a crime that he didn't commit.
Mr. Manley, and I've told you, all that can be brought up at the trial, and we will deal with it at that time. You've been charged, but nothing's happened.
Oh, nothing happened? Man, a whole lot happened to me.
As far as no, let me correct that. So nothing has happened as far as whether you're found guilty or not. Okay, that's what I meant. So we will do that on the 24th at 1 o'clock Eastern time, and I will see you then. All right? Okay.
Your Honor.
Thank you, Ms. Pitstick. Thank you, court. Appreciate it. And and Mr. Manley, you're in Texas, is that right?
Yes.
So that's why we had this via Zoom, so that you were not inconvenienced for coming to court today, and you could.
Can the civil matter, since this is civil matter, can that be held via Zoom? I would like to put that request forth that this civil matter be held via Zoom because it's causing an undue hardship on me. So I appreciate this. This was very good for me to be able to do it this way.
Mm-hmm. Okay, Ms. Pitstick.
Do not agree or consent to the defendant appearing by Zoom.
Okay. All right, well, under the current rules, without both parties agreeing to it, it's gonna have to be in person.
Okay. All right.
All right, sorry about that, Mr. Malin.
No problem.
So, okay,
Okay.
all right. Okay, well, thank you, sir. All
Thank
right.
you.
Have a good day. Bye.
Bye.